Hello, and thank you for joining us. My name is Katie Perez, and I'm a senior associate at Scott Legal PC. Today, we are going to spend some time talking about how to get an EB-5 investor green card. Now, as you'll learn today, the EB-5 program provides a path to U.S. permanent residency through investment. Just a few things before we get started. Some of you may know that the firm was founded on an E2 visa several years ago. Our founder is in the U.S. on an E2 visa and has been on several different visas, including an F1, ATN, B, and H1B. As such, we know what you are going through. Scott Legal is a full-service immigration law firm, and we offer immigration services in several different areas, including E2, E1, TN, L1, family immigration, national interest waivers, EB-5s, extraordinary ability visas, and more. We will continue this webinar series, doing at least 2 webinars a week on different topics. At the end of this webinar, we will send out several useful tools. We will send you a copy of the PowerPoint presentation from today, a link where you can download guides that go through the visa options in more detail, and also a link where you can sign up for additional webinars. This webinar will be recorded and will be available on YouTube. We will also send a link for that. We encourage you to subscribe and hit the notification button as we regularly upload immigration videos on a wide variety of topics. We will also send you a link where you can arrange a consultation with one of our experienced immigration attorneys if you would like to discuss your case in more detail. If you have any questions throughout the presentation, please put them in the chat box and we will address them at the end of the presentation. Today, we are lucky to have Ian Scott with us. Ian is a graduate of Harvard Law School and the founder of Scott Legal PC. As I mentioned earlier, he is in the US on an E2 visa and has been on several other visas. He has a wealth of experience handling a variety of immigrant and non-immigrant visa petitions, including the EB-5s. So without further delay, let us get started with the webinar.
Great, thank you very much, Katie, and it's great to be here and to go over the EB-5 requirements with you. And yeah, and definitely, I think that there will be a lot of great information here. I'm not sure why I don't know why the photo doesn't seem to be, the image doesn't seem to be moving to me, which it should be. But let me see why it's not doing that. Just bear with me just for 1 second. Okay, I'm not sure. I'm not really sure why it's doing that, but we will just proceed anyway. Okay, perfect. Okay, so let's first start with the kind of the profile of someone who's looking to do an EB-5. So with an EB-5, there are 2 ways of entering the EB-5 program. The first way is that if you are going to do what is called a regional center, and a regional center, when we think of a regional center, just as an example, think of something like the Hilton hotel chain wants to build a new hotel in a particular part of the United States, and they want to raise, let's say they want to raise $100 million or something like that. And what they do is they say, okay, well, I'm going to utilize the regional center program and I'm going to attract investors that also want a green card. And those investors are going to invest into this building of this hotel. And then the regional center would do everything. They would take the money, they would build the hotel, they would hire employees, they would do everything that was required. And so when someone is interested in EB-5 under a regional center, they're really looking at EB-5 in the context of a passive form of investment. So they really are, they don't want to do much. They just want to give the money. They just want the green card. The administration fees, usually the regional center charges a fairly significant administration fee for this. They may charge a fee of up to $35,000 or $50,000, $35,000 to $50,000. So the return ends up being actually a negative return. So because the actual return that they may offer may be a fraction of a percent, and so the person actually is not making money, they're losing money, they're not getting a real return. So when you look at the profile of someone who's doing this, it really is a person who is just interested in getting the green card and wants a minimum amount, a very minimum amount of work associated with that. The other thing to consider with a regional center is that although the regional centers have to get some type of USCIS approval, and USCIS is the government, an agency in the government, they are not government approved. So it doesn't mean that when you invest in a regional center that it has some type of government backing or some types of government security. This is an investment just like any other investment. If the investment went bankrupt or belly up, you would not only lose your money, but you would also lose the ability to get the green card. So it is an investment. So you do have to work with an investment advisor as well to make sure that it is an investment that you are actually comfortable with. The other aspect with respect to regional centers is that when we get into the details of EB-5, you'll see that there are two significant requirements, one of them being investment, the other being job creation. And one good thing about the regional center is that it does allow for what's called indirect jobs. So if this Hilton hotel was put up and the Hilton hotel chain was such that that particular hotel would hire people that direct jobs, people that worked at the hotel, the front desk person, the people who clean the rooms, the people who organize and manage, etc. But then also what indirect jobs will look at is as a result of the Hilton hotel chain going up, there may be a dry cleaner or a restaurant that's nearby. And what we get is an economist to write a report, and the economist indicates that as a result of this particular project, there are a number of indirect jobs, and those can be counted. So that sometimes can be very helpful can be helpful for this. And then with the regional center, it's the only way to really pool investment. So regional center can give 100 people a green card. A particular project can give, many people a green card. Whereas a direct investment, which we'll talk about next, only one person per entity can get a green card. So in contrast, the direct investment really is looking at the situation where, really looking at the situation where the individual wants to have a lot more control over their investment. So there is only one investor that's allowed per entity, and this is maybe somebody who might be in the US on an E2 visa and then decides that they want to have a green card, so they may be investing in their own business, or they can be investing in someone else's business, or they could just be starting a business in the United States. All of those could qualify for direct investment. And again, this is going to be someone who doesn't want a passive investment, doesn't want to pay the high administration fee, or doesn't want someone taking control over their money. They want to do it themselves. So in terms of the job creation, they're doing it themselves. In terms of running the company, they may be doing that themselves if they have an active role, active role in the company. So really two very, very different investor profiles that you see. And although the fundamental requirements are very similar, very, very different profile of investors. Now, what I will say is that probably around 90% of the people who invest in the EB-5 program invest in the regional center program. So there are not a lot of people who invest in the direct investment. There are 10,000 or so visas issued a year. So you're looking at maybe about 1,000 of them that are doing direct investment. But our firm does tend to handle a lot of direct investment EB-5. So I think that we have a lot of E2 clients that want to find a way to move to a green card. And as a result of that, use their existing businesses to move to a green card. So the things that we're going to cover today are the fundamental requirements of the EB-5. The first, and maybe just kind of break it up into three larger sections. One is the investment, like what do you have to invest, when do you have to invest, and how much you have to invest. The second is what do you have to do with the business? And that's going to be primarily job creation, and that's going to be very specific, a specific number. And then exactly how do you file? So what are the filing requirements related? And when we get into that, we will talk about timing as well, because there are some unique aspects to EB-5 related to the timing. So first, let's talk about the investment. So the investment amount is going to be either 800,000 or 1,050,000. And the difference between those two is going to depend on where it is you make the investment. So where is your business located? So if the business is located in what's called a targeted employment area, then you're going to, or a rural, targeted employment area, then you're going to invest $800,000. Anything else, you're going to invest 1,050,000. So now what does targeted employment area mean? So targeted employment area, there are two ways that something can be a TEA. One is that the unemployment rate in the census tract of that particular area is 1.5 times the national average. So let's say the unemployment rate right now is 4%. So if in a particular area the unemployment rate was 6%, then it could qualify for TEA, being in TEA. And the other area is a rural area, and that's going to be designated by the local jurisdiction, country rural area. It's going to be that designation. And now either one of those are going to be TEA, what's considered a TEA, targeted employment area. And if that happens, you invest 800,000. If not, you invest the higher amount. Now, the 800,000 will become very, very important. We're going to talk about that a little bit later, not just because it's $250,000 different from the higher amount, but it has to do with visa availability. And especially if were born in China or India, the most people will be looking for the $800,000 investment just because they'll be able to get their green card. They'll be able to get their green card a lot faster, right? So that's something that's something that we're going to talk about in a little bit more detail as we move forward. So the other thing is that the money doesn't have to be, when we say investing the 800,000 or the 1,050,000, the money doesn't have to be invested in a business that was just started. Even though the terminology in the regulations say that the investment has to be made in a new commercial enterprise, that's defined in the legislation, an enterprise that was started after 1990. Now, so you could have an enterprise that was started in, let's say, 1995 or something like that, and the enterprise is already up and running, and then you decide to invest 800,000 or 1,050,000 in that particular enterprise, and that could still qualify as a new commercial enterprise for this. And again, you could do a startup, which under direct investment, or you could do a regional center. What I will say is that all regional centers that you see do meet or at least purport to meet the $800,000 requirement, because they're set up to try to meet the TEA requirement, right? Because most people do want to invest less money, because investing the additional $200,000 doesn't get you any additional benefit. It's just more money that you have to invest in that the other party is holding on your behalf. So what is included? And how can the investment be made? So the investment can be made over time. We did a direct investment EB-5 where the individual was in the United States on an E2 visa, and they had a farm, and at that time the investment amount was 500,000, and they invested $100,000 over around a 7 or 8 year period. And all you have to do is you have to look at the money that was invested and track it over time. And once you get up to the requisite amount, then you can file the petition. We do strongly recommend that you actually do invest the full 800,000 before you file the petition. There are some practitioners that advocate kind of filing before you've made the $800,000 investment. And well, I think that that's one interpretation of the regulations, but I do think that an individual runs the risk of getting to almost the end of the process and then the government saying that you didn't meet the $800,000 investment requirement. So we've never done an EB-5 where the person has not invested the full amount before they filed a petition, and we strongly recommend against it. I'm not even sure if our firm would file one, because I just think it is 5 or 6 years down the road, the applicant will run into difficulty. So the other thing with the investment has to be money that you, the investor, has possession and control of, and it can't be retained earnings. So what I mean by that is, I mean a few things with that. So one, you have to be in possession and control of the fund. So you can't invest money that you don't personally control. So for example, some time ago, the individuals would do EB-5 for their children who maybe were in the United States studying. And at that time, it was $500,000 investment, and they didn't want to put the money in the children's bank account. So instead, what they did is they said, okay, well, we're going to invest in a regional center, and then we're going to send the money, the parents would send the money directly to the regional center and then give the child a gift letter saying that this is a gift to the child. Well, USCIS said that that didn't qualify, and they denied those petitions, saying that the individual investor did not have possession and control over the funds, right? So what we do now, and we make sure that this is done and it's never an issue now, unless people don't know about it, is that in this particular case, we would get the parents to put the money into the child's personal bank account, and then the child would take the money from the personal bank account and invest it in the regional center. But It's an example to show that the individual has to be in possession and control, because you could have a similar example where the individual has an existing business and they're going to start a new EB-5 business, and then they transfer money directly from their existing business to the EB-5 business, and that would be a big problem because the money has to go to them first. Also, retained earnings doesn't qualify. So let's say someone has an E2 business and they make $3 million net income in that business, and the money is sitting there, and then they say, hey, I have $3 million in retained earnings. I'm going to keep the money in the company, and then I'm going to spend it next year, and then next year I'm going to apply for EB-5. Well, that doesn't work, because that's just money that the company has accumulated, and it's not money that you have invested. So it's the same reason that it doesn't work, because you don't have possession and control of the funds, and you didn't invest the money. It could work if you paid the money out to yourself and paid taxes on it, and all of this went through they paid it to your personal account, you paid taxes on it, and then reinvested it in the company. But that gets really confusing, because the USCIS is extremely exacting with respect to the investment, and even what can be included. Because, for example, for EB-5, the regulations don't allow you to include legal fees or other administrative fees. So if let's say you invested just $800,000 and you spent $20,000 of that 800,000 on legal fees, and you included that in your schedule and then submitted that to USCIS, they would deny the petition, because they would say that you didn't invest 800,000, you invested 780,000. So you have to look at the very specific rules of what can be counted as investment, what can't be counted as investment. Definitely, EB-5 petitions need lawyers. They're not easy petitions to do, and even very few lawyers specialize in EB-5s. Even people who specialize in E2s don't specialize in EB-5s often. So the other big part of the investment has to do with source of funds. Both E2 and EB-5 have a requirement that you have to prove that the money came from a lawful source. But the E2 requirement is quite straightforward, and we often, especially if the individual comes from a Western country, we often will provide very little documentation for consular filings. We'll provide very little documentation related to the source of funds. And but if it's an EB-5 petition, it is like an audit, right? So even if something, just to contrast the situation, if someone was doing an E2 and they sold their house and used the money from the sale of their house to invest in the E2, all we would show is the documents related to the purchase and sale of the house and the money going into the bank account. That's all we would show for an E2. But for an EB-5, we'd actually have to show where the person got the money originally to buy the house, right? And even if that was 10, 15 years ago, USCIS does not care, right? Doesn't matter how long ago it is. If you don't have the evidence, they'll deny the petition, right? So sometimes you can, if it's long enough ago, you can provide alternate evidence, or evidence that is maybe not as, like you may not have all of the bank statements, but you have to provide some corroborating evidence to support a claim, because they're not just going to accept that you did it and then you just don't have the documentation for it. So and as I said, the EB-5, or maybe I didn't say it, but I will say it, the EB-5 source of funds is not for the faint of heart. It is, as I said, it's extremely exacting. And we've had many, many clients, none of which we thought that the funds came from an illegitimate source, but we've received some very, very, very detailed RFEs. And, they, like I said, it really is like an audit. So it's just, and what I would say is we're very good at this, because we have a good idea of what USCIS wants with respect to source of funds. And but the problem comes in, sometimes we know what they want and we communicate that to the client, and then the client doesn't have it, right? Because sometimes, again, if the transaction occurred a long time ago, that makes it, and they can't get bank statements, then it makes it difficult difficult for them to proceed if USCIS does in fact come back and ask for information. The investment does have to be an equity investment. You can't, for example, say, okay, I'm going to loan the company $800,000 and then take back a loan. There could be no guarantee that you can get your money back, or that you get any type of return. That this has to be what's called an at-risk investment. So that's something that you have to keep in mind as well. So the next big part of EB-5, so we talked about the investment a little bit. The next big part of EB-5 is job creation. And so here they are very specific. And with E2s, The government doesn't say exactly how many jobs they want. When we look at L's, they don't say exactly how many jobs they want, even though it's not an actual requirement, but it's implied that if you have executive or managerial duties that you're going to have employees. They don't kind of talk about how many, but EB-5 does. EB-5 says we want 10 jobs. And not only do they say we want 10 jobs, they say we want 10 full-time jobs. Now, the statute does talk about shared jobs, not part-time. Shared does not mean part-time. Shared is a complicated definition that we tell people don't ever try and meet it, right? We say hire 10 full-time people, right? Because as I said, it's a part-time, two part-time people working 17.5 hours or 20 hours a week. It does not equal what the definition of a shared job is. So we tell people not to bother doing that and to hire 10 full-time people. Now, the other thing with this is that 10 full-time people have to be US citizens or green card holders. So we strongly, strongly suggest to people that they should register with E-Verify, because we have had a situation where we were filing just the I-526 petition, and just to show that the company, this was the same farm that I was talking about because it had been operating for a long time, just to show that, the person was going to be able to meet the 10 full-time job requirement, even though we didn't have to prove it at that point. We included some green cards and other information proving that these people qualified for jobs. And lo and behold, USCIS looked at them. And there were a couple of them where they said, they didn't tell us which ones that they were, but they said that these people are not either U.S. citizens or green card holders. And the idea here is that if you do E-Verify, then they're already doing that check, right? So you don't have to wait till you submit the petition to find out someone gave you a fake green card or someone gave you a fake, U.S. passport photo or something like that. So that's something that's very, very important. We strongly, suggest registering for E-Verify so you don't run into those problems, because they're very specific about the jobs that they want. You do have quite a bit of time to create the jobs. You have 2 years after the I-526 petition has been approved, and we're going to go over the filings, and we'll talk a little bit more about that timing in a bit. The business plan, there's always going to be a business plan, whether it's a regional center, there's going to be a business plan, or a direct investment, there's going to be a business plan. The business plan does have to be credible. One of the key cases that deals with this has to do with a person who did an EB-5 investment and had a 3-page business plan, which the government found insufficient and denied that petition. And they described what are the types of things that they expected to see in a business plan. And that case is kind of the framework for how it is we pull together business plans. And we talked about documenting the full-time positions. So the filing. So how do you file for EB-5? So you file a number of different petitions, and this extends over many, many years. So the I-526 or the I-526E, if you're doing a regional center, is the first petition that you file. And this is the petition that says that you've invested the 800,000 or 1,050,000, and that you are going to be able to create the full-time jobs, right? That's what this particular petition is. That is going to be something that you file with USCIS, whether you're in the United States or outside of the United States. And then the second part of the filing is going to depend on where you are. So the second part of the filing is really the same process for any green card filing. You're either going to file an I-485 or you're going to do consular processing. And that's really going to depend on a number of facts and circumstances. But one of the things that you always have to look at is the category current, right? So if the category is current, so right now, if you are investing $800,000, that's always going to be current. And for most countries, both the 800,000 and the 1,050,000, that's current. But for nationals born in India and China, unless you're investing the $800,000, there is a delay, right? So now what the delay means is that you can't, if the category is current, and you're in the United States, you can file the I-526 and the I-485 concurrently, which is extremely beneficial because you can file for work authorization and travel authorization at the same time. And if you're not in the United States, or you have a situation where you can't avoid travel, because we have some people who are in the United States, they might be on an E2, but when you do file an I-485, there's probably going to be at least a 9-month period where you're unable to travel because you have to file for permission. I don't fully understand why that rule exists, but you have to file for permission to travel, and that can take 9 months or so. So as a result of that, some people decide that, well, the only thing that they can do is consular processing. And then the final part of the petition is after you get the green card, 2 years after you get the green card, you have to file another petition, an I-829 petition, which shows that the conditions have been removed. So that what that means is that you actually have hired the 10 full-time workers. So it is quite a long process. And just to kind of go over the timing for the I-526, that could take 4 to 5 years. Unless you're in a rural area, it could be a lot faster because the government has expedited those petitions. And once that's approved, because the I-485 can't be approved until the I-526 has been approved, although it can be filed concurrently, that's probably going to take another 18 months. And then once you have the green card, you have to, 2 years later, you're going to file the I-829, and the processing for that is going to be 3 to 5 years. So you're going to be in the system, in the immigration system, for well over 10 years when you do EB-5. So, but for a large part of that, because one of the changes in May 2022, March 2022 rather, is that the I-485 was changed where you could file that concurrently, because before you had to have approved I-526 before you could file an I-485, but in March of 2022 they changed that, and that gives people a significant amount of benefit because especially given the long delays, they can actually live and work in the United States for an extended period of time. So the key changes to the program, I just talked about these, the EB-5 Reform and Integrity Act. It was passed in March of 2022. The investment went up, the lower amount went up from 500 to 800,000. The higher amount just went up $50,000. It was $1 million before. So, but the 500,000, that was the amount since the beginning of the program. So maybe an increase was, even if you look at just inflation, which has been quite high, probably is warranted. The program authorization, so the regional center program does have to be authorized every once in a while by Congress. The other program, the direct investment, doesn't. That's already just in legislation. That doesn't need authorization. But part of the change in 2022 came with the problem that for about a year and a half, Congress didn't do the reauthorization. So USCIS just had a bunch of petitions that they weren't adjudicating, and because they didn't know whether they could adjudicate them or not. And then finally, in March of 2022, when they passed the reauthorization, they started adjudicating. But what they implemented a number of interesting changes. One that said that if you file your petition before, because the next time it has to be reauthorized is September 30th, 2027. So they said if you file your petition, a year earlier, before September 30th, 2026, then they will adjudicate it, right? So that just eliminates that issue. Unfortunately, if you file it after that, they likely won't, given this is pretty specific in terms of the dates. There were some changes that were made to TEAs. TEAs were a lot easier to get. You could string census tracts across multiple, like as long as they were adjacent, you could, like they were basically saying that Manhattan, the middle of Manhattan was a TEA because you could do a census tract that went right through the Bronx and other places that made it so that it was over 1.5 times the unemployment rate. But now those ways of doing that have been eliminated. So it's a lot harder to get a TEA designation. The other kind of big change in 2022, there were a few of them, but for the purposes of this, it was these set-asides, these carve-outs related to rural areas, high unemployment areas, and infrastructure projects, where they said that for these, they're going to carve out a certain number of visas. So if they're 20%, that means, of the 10,000, they're going to be 2,000 or so that are carved out. And this really created a situation where nationals from China and India right now still can apply for, if they're doing it now, they can apply for an EB-5 and really jump to the front of the line, because their colleagues who applied before 2022 are still in the queue that existed before 2022. So we talked about the ability to file I-485s concurrently. You can file work authorization, travel authorization. They made some changes to the administrative fees. So they said you can't include them, but they said that you do have to still provide source of funds information for them. The clarification with respect to loans and gifts. What USCIS wanted to do, because we saw the proposals that they were suggesting, was that they wanted to limit the gifts in particular. I don't think they were dealing so much with loans, but they wanted to say gifts could only come from immediate family members, right? So I think that was one of the proposals. But then in the final pronouncements, the gift was fine. But with gifts and loans, you do have to still do the source of funds. So if your friend or family member gives you a gift or a loan, then you have to show where they got the money from, right? And so can be quite an extensive exercise. And then they implemented some protections if a regional center were to fail. Another thing to consider, another, considerations with respect, or other considerations with respect to EB-5 is that the investment, and this has more to do with direct investment, this first one, that same case that I talked about with the business plan, that was a case where an individual wanted to do EB-5 direct investment. He put $500,000 in a bank account and he submitted a 3-page business plan and said, give me EB-5, give me the visa. And they denied it. And he went to an appeals board, and the appeals board said, no, no, the denial was accurate, but they actually went into a fair amount of detail and went on about the business plan. But they also went on, the case is called Matter of Ho. They also went on about the investment. They said you can't just put money, 500,000 in a bank account, and you're the only owner of the company, and say that you have money at risk because you can just take that money out. So they said that we don't just want the intent to invest, but you have to have spent some of the money and show that you have commitments against some of the money. So that can be a balancing act because they don't say exactly what that has to be, but what they do say is just putting money in a bank account and applying is not sufficient, right? So, and we talked a little bit about loans and gifts already. Maybe one other comment I'll mention about loans is that loans can be unsecured, secured. If they are unsecured, no problem. But that was another interesting lawsuit where unsecured loans were fine for a long period of time, and then USCIS one day just changed their minds, said unsecured loans are not fine, and started denying petitions. But then a group of people got together and sued and said, well, that's not what the statute says, that it's our interpretation is different, and a court agreed with them. And now unsecured loans are fine, and those petitions that were denied just because of the fact that they were unsecured loans, those were ultimately approved. And now unsecured loans are fine. Secured loans are fine. The issue with secured loans, if you let's say that you take out a secured loan and it's against your house, that your personal home, then you have to show where you got the money to buy the home again, right? So it can be very complicated. The only time you don't want to do security is if the business itself is the actual security, and that's where you want to stay away from that type of loan. And then we talked about gifts. And well, maybe the other thing to mention about gifts is that with gifts, you do have to, there has to be a gift letter. You have to do the source of funds, but also you have to make sure that you're adhering to whatever the law is with respect to gifts, because a lot of countries don't just allow people just to give gifts, right? There's a gift tax and things like that. And by the time USCIS gets to the petition, which could be years later, they might say, show me that you paid the gift. If this was a legitimate gift, show me that you paid the gift tax on this. Or they might say, show me that you didn't pay it back or whatever, right? So keep in mind that the review is happening many years later. And also keep in mind that the people who are doing this, the people who are doing, like EB-5 is highly specialized. So it's examiners that are kind of segregated and put aside, or like, I mean, I think that often you'll have examiners that are used to adjudicating a particular type of petition, but this one is completely set, like, it's completely separate, and it's not their first rodeo, right? Like, so they know what they're doing and they know what they're asking. Although we've gotten some, crazy RFEs, like, it's not that they didn't make sense, it's that they were asking questions about what we submitted, right? And wanted more, often wanted more. So they do know what they're doing, in terms of petitions. So you do have to make sure that this isn't the let's see what we can, like, if it is a gift, it should be a gift. If it is a loan, it should be a loan. If it's a loan, you have to make sure that you are in a position when they come back to you 3, 4 years or 5 years later, that you can show loan payments, because they can ask for that, right? They can say, I want to verify that this actually is a legitimate loan, and you want to show loan payments. And if they issue an RFE and you can't show that kind of stuff, then they will question the veracity of the other information in the petition and could deny it. So the investment structure, unlike E2, it doesn't matter how much you own. You just have to own something. It can be a fractional percentage. It doesn't matter. And I mentioned before, you can't have kind of guarantees on, guaranteed return the investment, or return on, like, that the company guarantees that you'll receive 2% a year or things like that. So all that kind of wording can kill the petition, because then they say that the investment is not at risk. We talked about some of the differences between E2 and EB-5. The source of funds is a big one. The fact the legal fees for E2, we can include them, but not for EB-5. The job creation is specific for EB-5, but not for E2. And the other big difference is that for E2, it's completely fine just to buy a business, right? Like someone has a restaurant and you say, hey, seller, I want to pay you $200,000 for your restaurant. You have three employees, four or five full-time employees, and that's fine. And they buy the restaurant and easy E2, $200,000 investment. The person has four employees, so even when they go to renew, as long as you keep the employees, it's not going to be a problem. But buying a business for EB-5 doesn't work because the money has to go towards job creation. The investment has to go towards job creation. And if you're just paying a seller for the money, the business, and the seller gets the money, then that's not going towards job creation. If you're investing in the business and putting the money in the actual business and then using it for future job creation, that could work. You still have to create 10 new jobs, not the ones that were already there. But that's something to keep in mind, is that buying a business often does not work for EB-5. Okay. Um, so so I think that so let's take a look at timing considerations. So we do have unfortunately the timing considerations related to EB-5 are not great, right? So the EB-5 program, the I-526, is taking 4 to 5 years to be adjudicated. If you sue them for doing a mandamus petition, they will challenge everyone, and that's not even this administration. That was before they would do that. They don't back down on those anymore. They used to be there. It was a time that if you sued them, they would just go to your petition rather than fight. They just adjudicate it. But now they don't. They will they'll do a motion for summary judgment, or so you actually have to fight it, and those can be so it can be expensive, right? Because usually that type of adjudication is by the hour when you're hiring a lawyer to do it. So often you can't really speed up the time very much. It could be 4 to 5 years, and then we talked about the timing already for the other parts of the petition. And you have to kind of consider that with what is your underlying visa, and you have to look at it in terms of dual intent considerations, because your underlying visa might be a TN. If it's a TN, or where your ability to renew might be jeopardized based on the fact that you have an immigrant petition pending, you have to kind of consider that. If it's a dual intent visa like an L or an H, then you may be in a much better position. And often people will have parallel green card strategies, especially in this situation where the wait time is so long, and we have people, they start an EB-5 and then they marry a US citizen. We have had someone who did an EB-5 and it's still pending, but he also did an NIW the NIW was actually a long shot, but it ended up getting approved. And so now he doesn't actually need the EB-5. So people will often do parallel green card strategies to cover their bases, and really, I think with that, the planning is key. Perfect. And I don't know, my other screen unfortunately went blank, so I can't see the questions. But Katie, you can let me know if there are any questions in the.
No, I don't see any in the chat box at
Okay, perfect. Okay,
this
sounds
time.
good.
Mhm.
Excellent. So no, that's great. Great. Thank you everyone for joining. And as Katie had mentioned, we'll send out a number of pieces of information, this PowerPoint, the link where you can see the webinar. We have a guide, an EB-5 guide that's helpful, and we'll also send out a link where you can set up a consult if you have any specific questions. Perfect. Great. Okay. Thank you very much. Take care.
Thank you.
Bye.